Hello, everyone. Thanks for joining us. I'm Taylor Wall, Senior Director of Education for the NGCOA. We're excited to have Rick Hackman join us. He's the chair of the Labor and Employment Group at Saxton Stump Law Firm. And of course, we are covering all things Department of Labor, specifically the new Independent Contractor Ruling. We'll have some great information for you today. We'll get going here in a second. A quick housekeeping note. You're likely either viewing this on YouTube, LinkedIn, or Facebook. If you have any questions throughout this presentation, comment them at any time. Ronnie, our Senior Director of Advocacy, and I will be monitoring them. We'll try to get them to Rick as soon as we can, and he can address them. And of course, if you're viewing this after the fact, this is not tuning in live, you can always watch it on demand on any of those platforms I just mentioned. If you have any questions, feel free to send them to us here at NGCOA. We're always happy to help. So without further ado, we will bring Ronnie and Rick onto the stage. And thanks again for joining us.
Thanks, Taylor. Welcome, everyone. Thank you for joining us today. Since the release of the new Independent Contractor Rule, we've been working hard here at NGCOA to update the golf community on the impact this rule will have on our industry and how we can help you navigate this new rule and to ensure that your business model is sustainable. And if there's alternate ways to do business, lessons learned, sharing that information with all of you, that's why we're here, and that's what we're doing every day. To help us with this education piece, we invited Rick Hackman, who's an attorney, to help us answer your questions and present a little bit of update on where we are with the rule. Realizing that within the ABC rule, which applies in about half of our states, we will be talking about the Department of Labor's Independent Contractor Rule. But if you have questions on the ABC rule and understanding that each state is different with the ABC rule, but we'll try to take that question and answer the best we can. So with that, Rick, I'll turn it over to you and let you begin your presentation. Thank you.
Thanks, Ronnie. I appreciate the intro, and good afternoon, everyone. I hope everyone's heart rate has settled back down after the end to the players this weekend. It was pretty exciting stuff. This certainly does not qualify as pretty exciting stuff for the most part, but it is important information. And as Taylor and Ronnie indicated, my background is I'm generally a management side attorney. I've been doing this for 25 years and represents clients, companies mainly, with respect to independent contractor rule issues, overtime, harassment claims, and all other manner of practices before the Department of Labor. So it's a timely issue that we want to discuss today. And principally, I'd like to just give you some background here on the rule and how it may apply to your situation. But I also welcome questions, and hopefully we get questions on an ongoing basis, because listening to me lecture about this rule for the next 30 minutes or more would be less beneficial than having individual questions. I would mention that with respect to questions, I know people will have detailed questions. I am not your attorney, so the advice I give will be general advice only, and I can't really apply it to your specific situation. If you have specific legal questions, you would need to actually speak with your own attorney. So having given you all the legal disclaimer language, let's get right down to it. So the principal issues that we're going to deal with today with respect to the presentation involve challenges, not only challenges by operators, but challenges with respect to contractors, what the benefits and detriments to independent contractor relationships are. We'll talk briefly about the current rule. We'll talk briefly about the ABC rule, which Ronnie referenced, and some of the steps that both contractors and operators can take in order to solidify these relationships. And we'll also throw in a few best practices. So who are we talking about here with respect to independent contractor? What industry professionals are affected? Golf and tennis teachers, instructors, coaches, caddies, Potentially clubs have fitness instructors, and there's other service professionals engaged by clubs on an ongoing basis, photographers, videographers, even some forms of catering services. So the challenge that we have is, as a result of recent legislation, and we talk about recent legislation. So we have a situation where the independent contractor rule, it's always been out there, but there's been tweaks, from year to year and from administration to administration. It's not really, excuse me, it's not really getting into a political discussion to mention that it does matter who is in the White House and who is in control of Congress as to how these rules are promulgated and how they change. So, and I'll talk a minute about the difference between the prior rule under the Trump administration versus the new rule under the Biden administration. So where you are now as a contractor, as an operator, is you're faced with this decision as to revitalize your independent contractor relationships and make sure they meet the facets and elements of the test, or form an employment relationship. So, what are the benefits of an independent contractor relationship? I think a lot of people know these already. You want to live free. You want to be out on the course. You don't want a 9-to-5 job. You want to be able to accept or reject jobs as they come, especially if you're talking about caddies. There's particular golfers that you don't want to work with. You want to be able to free to reject those jobs and move on to the next. You have varying clientele, and as a contractor, you're going to get paid. In most cases, you're going to get paid almost immediately, whether it be by cash or immediately cashing out with the club. And benefits for the operator, they're pretty obvious, and I think most are aware of it. There's no requirement for income tax withholdings. Everything would be via a 1099, an independent contractor relationship, no Social Security, Medicare taxes, no requirement for workers' compensation or unemployment taxes, employee benefits, leave, health insurance, all those things fall by the wayside with respect to independent contractors. The other benefit of independent contractors is you have folks who have unique skills, background, experience, expertise. You have some instructors who are young and who are novice. You have some instructors who've been around the course forever. Maybe they were a former golf coach. They've been golf instructors their whole lives. So you have the ability, with respect to independent contractors, to offer your clientele at the club, people with varying levels of experience and knowledge. Another benefit with respect to an independent contractor relationship for an operator is that in most cases, the operator, the golf course, the owner will be shielded from liability under employment laws. Fair Labor Standards Act involves payment of overtime and back wages. Title VII, as most people know, involves a prohibition on discrimination against race, sex, religion, and other protected categories. Independent contractors under federal law don't have the same protections as employees have with respect to these issues. So, by way of example, if an operator has an independent contractor relationship with a caddy, and the caddy is alleged to harass a golfer, in most cases, the golf course owner and the operator won't be liable for that harassment. I mean, their course of action in that case would be just to terminate the caddy, but there would be no employment liability because there's no employment relationship. So the downside to employment for the contractor, you're restricted in your ability to reject certain tasks. So if you're employed as a caddy and you're not out on the course and you're an employee, the operator can ask you or require you to perform all manner of other functions, work in the pro shop, clean the locker room, course maintenance, whatever it may be. So it's going to be a broader relationship, and it's going to be it may involve tasks that as a caddy, you're not interested in doing. So that's certainly one detriment to being an employee as a caddy or an instructor. The organization, the operator sets the hours. So you have to be in here from 7 a.m. to 5 p.m. every day. The hours are set. It's not an opportunity for you to pick and choose as to what you want to do and when you do it. If you're an employee of a course or of an operator, they have a right to restrict your ability to work elsewhere. So you may have lucrative gigs on the side at other courses. If you're an employee of a course, they may be able to limit your ability to take up those additional jobs. And then finally, club control over your duties, your attire. So the club can require you to wear their attire and comply with all the rules and regulations of the club with respect to a variety of issues. And I guess the other thing I would mention here briefly is that when you have this employment relationship, as in any employment relationship, the chances are that at some point, if you do a poor job, you're going to get terminated. And those terminations tend to follow you around a little more than if you had an independent contractor relationship and the operator just tended not to use you anymore for purposes of providing services. Downside to employment for the operator, again, is sort of the reverse of what we talked about before. We're going to be requirement for payment of taxes, the increased employment-related liability. And again, it limits options for members and for the public. So if coming to your course means I have to see the same instructor every time, or I have to use the same caddy every time, that might not be appealing to me. I may say, you know what, Rick is a terrible caddy. I don't like using him, but he's really the only option. So you know what, I'm not going to go to Ronnie's golf course anymore. I'm going to go somewhere else. So it really gives you the opportunity to broaden the scope. And, it gives the opportunity in a lot of cases for a golfer who has a prior relationship with another caddy to use that caddy at the operator's course. So what's this all boil down to? It's all down to the legal stuff. The traditional Department of Labor economic reality test, I don't even have to read this slide to you. I mean, you can look at it. It's essentially legal, congressional, legislative, circular doublespeak, as everyone's accustomed to in dealing with the government. So it talks about, well, the usual path is employees dependent on the business which he or she serves. What does that mean, really? Well, what it means, or what it did mean, it's a couple things. How do they employ that? What does that really mean to be dependent on the employee, the economic reality? And here's where, I referenced before, the differences based on administration, based on who's in the White House, who's controlling Congress. The Trump administration rule, which, as you would expect, was a little more employer organization friendly. It focused on two main factors, two core factors, one being the nature and degree of the worker's control over the work, and two, the worker's opportunity for profit and loss. So if you're looking at those two factors, most caddies, most instructors, most coaches would meet that test as being an independent contractor. Because again, if you're a caddy, hey, I'm going to be in today from 8 till noon. I can assist all morning. I'm an instructor. My hours are 2 to 4 today. Let's get people signed up. The course itself isn't really controlling the actions of those individuals. Same thing for profit and loss. It's pretty easy to make that determination. So yeah, if I come in 2 to 4, I'm going to get paid. based on my clients, based on who shows up, based on what lessons I teach. Under the Trump rule, there was 3 other factors, sort of side factors. So if 1 and 2 don't necessarily, if it's a close call between 1 and 2 based on the factual findings, and that's one thing I want to mention too. These cases, these situations are very fact specific. So there's not a global rule. There's not a rule out there that says, oh, if the organization sets the hours, then that person's absolutely an employee. No, it just doesn't work that way. All the facts are taken into account. It's sort of a totality of the circumstances test. So, under the Trump rule, if 1 or 2 are basically a wash and you really can't make the determination, it then kicks to the last 3 factors: the amount of skill required for the work, which, for instructors, I mean, that certainly in most cases would favor independent contractor status, because the instructor has worked at his or her craft all their lives for the most part, presumably, and have honed their skill. So they have the skill to be determined to be an independent contractor. With respect to caddies, with respect to fitness instructors, it may be a closer call. So as to whether they have the requisite skill required to be an independent contractor. The degree of the permanence of the relationship is a big one too. And I have clients in all manner of industry: roofing contractors, manufacturers, restaurants, retail service industry clients. And the one problem is that, and I'll liken this, I guess, to construction. So if you're a construction contractor, a general contractor, you have certain subs that you work with on an ongoing basis, and you want to maintain those relationships. But the problem you run into is, if you're using those same subs over and over and over for years and years and years, the Department of Labor is going to look at that and say, well, the subs are doing a lot of the same things that your employees are doing. And plus, these have been the same subs. They only work for you for a period of 5 years now. So to us, that sort of indicates an employment relationship and not an independent contractor relationship. And then finally is whether the work is part of an integrated unit of the employer, if it's an integral part of what the employer provides. And that, that's problematic too when looking at caddies and instructors, because yes, I mean, the reason we're in business, the reason we have a course, reason we're operating is to provide golf related services to our members and to the public. And, caddies are part of that, and professional instruction is part of that as well. So as I mentioned before, the Trump rule is certainly more organizational friendly, and it provides, in my opinion, more latitude to independent contractors who actually want to be independent contractors and do not want to be employees. And that's, something else important to mention, I think, is that just because a contractor wants to be an independent contractor, they don't want to be an employee, and they express that in writing to the potential employer, and the parties agree in a written agreement that, hey, they want to be an independent contractor, that doesn't necessarily carry the day, because I've been involved in a number of cases where there have been individuals who wanted to be independent contractors, did not want to be employees. They wanted the freedom to engage in other opportunities as an independent contractor. And the department looked at that and said, well, that's all well and good, but the intent of the parties is not necessarily going to carry the day in this circumstances. Every other issue here makes it look like an employment relationship. And just because one or both parties say they want to be a contractor is not going to carry the day. So, why are we talking today? Basically because the Biden administration rescinded the Trump rule and this core factor analysis that was in place. And wants to return to the additional traditional factors, which we'll go over briefly here in a moment. And, basically the current position of the Department of Labor is that they are presuming that every relationship like this is an employment relationship. And the burden is really on the operator in most cases to show that it's an independent contractor relationship. So with respect to where we are currently, the current rule as of just 8 days ago, the evaluation of, it's a 6-factor test evaluation here of degree of employer control. And this is really the big one. You know, how much control does the potential employer have and exercise over the work done by the potential employee contractor? I mean, does the operator mandate that they wear certain club-related attire, or their mandated shifts that various people that are required of certain individuals? How is the payment method handled? Is it funneled through the club and then to the individual? Does the club set the prices, or does the individual set the prices? Those all relate to the degree of employer control. Opportunity for profit and loss. I mean, if we're talking about a potential wash here with respect to the money that an individual could make, you know, that may weigh in favor of an employment relationship. But if it's truly an independent contractor relationship, it's going to show that, yes, I'm a contractor. I only want to take, I only want to take Ronnie out today in the course, and I only want to take Rick out today in the course. And if I decide at the last minute I don't want to take one or the other, I'm losing money. So that indicates a contractor relationship. If it's an employment relationship, under the circumstances, I'm more or less going to be required to take both of them out. Skill and initiative, we talked about that a little bit. I mean, a skill maintained by an instructor or a coach is certainly going to be an argument of an arrow in the quiver, so to speak, if you're trying to establish an independent contractor relationship because of that long background and expertise. I mean, caddies, it could be a little closer. Not to diminish in any way caddy skills, which are very valuable, but there are situations where, a court would look at that, or the Department of Labor would look at that and say, no, not understanding, in a lot of cases, the true nature of the caddy relationship, that these individuals don't perform a highly skilled employee. Permanence of the relationship, which is something that we just talked about, that could be problematic. I mean, if you're a caddy and you've been involved with this one course alone for a number of years now, and the services you're providing are caddy services, and maybe you're doing some other odds and ends around the course, under the circumstances, the Department of Labor may say, well, that caddy's been there for 3 years, been there for 5 years. There's a permanence of relationship there, which indicates employment relationships. Workers' investment, what equipment, what materials have been supplied by the worker. And with a caddy, I mean, it's difficult. I mean, do you have your own range finder? I mean, what do you bring to the table? What do you offer? And then the last one, which is very difficult to overcome with respect to this relationship, if you want to establish an independent contractor relationship, is the service integral to the employer's business? So yes, I mean, as explained before, I mean, caddies and instructors are integral. And, one other issue to keep in mind, especially for operators, is that if you have employed caddies and you have independent contractor caddies, that's going to be a red flag for the Department of Labor. They're going to look at that and say, listen, there's nothing special about these independent contractor caddies. They're doing the same darn thing as your employed caddies. So therefore they all should be employees. Just something to keep in mind. And as Ronnie mentioned from the outset, this is there's sort of a state by state application going on here. So again, there's not a bright line rule which really assists both operators and contractors in establishing the factors, because in many states they have what's called the ABC test, and I'll go over those elements in a moment. The federal rule is merely a floor for allegedly protection of rights of individuals who work for organizations. So states themselves can offer greater protections and make it even more difficult for employers to form independent contractor relationships. And that's really where we are with this ABC test. And an example of that, and I'm sure everyone's heard about the California AB5 gig worker bill. A lot of that revolved around Uber and Lyft and whether those folks could be independent contractors. And then numerous other states use similar variations of the ABC bill. A couple examples there, New Jersey and Georgia. But then some states just use certain elements of the ABC test, like Colorado uses the A portion and the C portion, which here they are. So with respect to the ABC, the contractor's work is not under the organization's direction and control. So that's similar to what we discussed with the prior rule, the Biden administration rule, as to the nature and direction of control. I mean, this is a little more strict in that contractors' work is not under, we're not talking about degrees here like we are with the federal rule. We're talking specifically the contractor's work is not under the organization's direction and control. B, it's outside the course of the organization's usual business. Well, for instructors and caddies, that's a huge red flag, because the normal course of business, again, is to provide services to clientele, members, and the public related to, walking the course, playing the course, and providing professional instruction. And C, the contractor has an independent business to do the work. So I'll talk about that briefly in a couple minutes about best practices with respect to an independent business. And so these ABC test is really suggesting that if you're going to be a contractor, if you're going to call yourself a contractor, and it's truly an independent contractor relationship, you ought to have your own independent business. So establishing and maintaining an independent contractor relationship, for contractors, documentation, and this is, Ronnie's promoted this nonstop. I'll promote it as well. Documentation is the key. You hear this, I'm sure, over and over again, but you want to make sure you outline and specify the rights, obligations, and responsibilities of the parties with an eye towards the factors. So if you're looking at the factors, again, who controls, backing up here, who controls the relationship? Skill or initiative? What are the nature of the services being provided here? Are they professional services? Permanence of relationship, and who's responsible for any equipment necessary? Those are the type of things you want to outline when you're talking about putting together written documentation. And for purposes of any relationship like this, you want to preserve any and all business related documentation, contracts, receipts, and document profit loss expenses, and invest in your own equipment if you're a contractor. So what does that mean? For golf professionals, golf instructors, it's going to mean something different. For fitness instructors, it's going to mean something different. I mentioned before, if you're caddies, you're bringing a rangefinder and whatever else is necessary to make your client, the golfer, more comfortable and to provide him or her with top-notch service. And for contractors, again, if you're a caddy, you want to make sure that it's communicated with the organization with whom you're contracting, the level of skill that you have, your knowledge of the course, your experience, and things along those lines. Those are all factors as well, which play into, whether it's going to be considered a legitimate independent contractor relationship. Other issues, I mentioned this before, establish your own business with an employer identification number. And you can go on various websites, Google, you can spend a couple $100 and form your own LLC and file certain things with the state to establish an LLC. That's one indicator of an independent contractor status. I mean, that isn't the end all be all. It doesn't affirmatively establish that this is an independent contractor relationship, but it is a factor. And it's an important factor that the Department of Labor would look at, because otherwise, if you're as a contractor being issued a 1099, and for purposes of the 1099, the organization, the operator is merely using a social security number, that tends to indicate that, hey, this isn't really a business. This is just an individual. And so under the circumstances, they should be considered employee. Work with multiple clients at various locations. I mean, that's something else. Don't just go to one course or work one course or one club. Instructors, get your own insurance, because that's another factor to consider if the Department of Labor is taking a look at this. Does an errant shot during golf instruction that breaks someone's car window, is that the responsibility of the club, or does that fall on the instructor's insurance because they have their own independent business? And then lastly, like I mentioned from the outset, if you have questions about this and how to make these determinations and what specific factors apply in your state, it's important to seek advice from an attorney or an accountant that you use. For operators, some of the same factors apply. Review your current relationships. So if you currently have independent contractor relationships, take a look at those agreements. If hopefully you have agreements, take a look at those agreements and review them in light of the factors. Go back to the 6-factor test, or if you're in one of the states that applies the ABC test, based on the written agreement as well as how it's applied. And that's the important thing to keep in mind too. You can write down anything you want. If you don't follow that, or if in practice that's not what's happening, then you're going to get called out on it by the DOL. They're going to say, well, that's all well and good. You say that Rick has the ability to control the services he provided, but guess what? You make him show up at 9 o'clock every day. You make him wear the club uniform. You do this, that, and the other thing. So under the circumstances, even though you're saying something in writing, that's not really what you're practicing. So elements of an agreement, and this is something, both for contractors really and operators. These are the type of things that you need to include in an agreement to make sure there's a valid independent contractor relationship. Term and length of the agreement. I mean, up here in the Northeast, it's more seasonal as far as the quote unquote golf season. Those down south, pretty much you're going to go year round, but make any agreements for a term, or for a length, or for a period of time, 6 months, something like that. And then, the parties can discuss re-upping them after the end of the agreement. Define specifically the scope of the services. What services are you providing? Professional golf instruction, professional caddy assistance, whatever it's going to be, but be detailed and make sure it properly describes what's being done. Compensation, avoid tying this to an hourly rate. This should be a lump sum payment for services provided. It's not going to be, well, if you caddied for 3 hours, you're going to get $60 or something like that. Control. I mean, and this is a standard sentence that you'll see in a lot of agreement, that contractors the exclusive right to exercise control, direction over the means and manner in which the services are provided. And, on and on about setting their own hours and providing their own instruction. Other elements to consider, the place of the agreement, where the service is going to be performed, who's providing the tools and equipment, what tools and what equipment is the contractor providing, what, if anything, is the operator providing, that it's a non-exclusive relationship. And this is important. If you're talking about an employment relationship, the employer owns the individual, because the employer has the right to mandate that individual only provides services at that club or that course, and with caddies that they only caddy at that club or that course. If you're an independent contractor, you're a free agent. You can bounce around to wherever the work may be. Make it clear in the agreement that there's no workers' compensation involved. And, under the circumstances, any incident at the golf course, some sort of limitation of liability provision in there that the contractor is responsible for that. Termination provision. There should be a termination provision in there that say either party can terminate this agreement upon 15 days notice or 30 days notice or whatever it may be. Do you as an operator want to require insurance? I mean, it's certainly something else to consider to solidify the relationship. And the same issue as I raised previously. Do you want to require anyone who performs contracting services for you to have their own independent business? So best practices, sort of wrapping up here, and hopefully we're going to get some questions. Setting rates. Contractors should set their own rates. I mean, there can be suggestions from the club. There could be a range provided or suggested, but let contractors set their own rates. Let contractors set their own schedules. Reimbursement for expenses. You need to be careful there. If you're going to reimburse an instructor or a caddy for certain expenses, we want to make sure we have that in the agreement. It's sort of an arm's length negotiation. It's part of the contract that we will reimburse you for this or for that. Avoid requiring performance of other duties. So yes, you're an instructor as an independent contractor, but we're also requiring you to work in the club shop on an ongoing basis. Requiring instructors or caddies to go through extensive training on how your club operates. Obviously, you have your own rules of conduct at the club, at the course, that you need to impart upon these individuals who do engage in contractual relations with you. But there should not be a situation where, like, if you bring in a new employee, you have this whole orientation period where you sit them down and you go over all the policies and all the procedures and every little thing that goes on in the workplace. So limited training, providing benefits. There's obviously, if it's an independent contractor relationship, there shouldn't be health insurance. There shouldn't be paid time off. There shouldn't be anything like that. I mean, certainly, if as part of being an instructor here, part of as long as you couch it in the agreement as part of the compensation for purposes of the contractor, you can offer discount rounds, free rounds, whatever it may be, for instructors or caddies. But again, that should be part of the agreement and part of the agreed upon compensation. It shouldn't just be ad hoc. Maybe we'll let you do this or let you do that. Let's put that in the agreement as part of the agreed upon compensation. Caddies, instructors, again, reiterating, set their own schedule and rates, and have the ability to accept or reject certain jobs. Because, if a caddy's had a really bad experience with one golfer, they should be free to reject going out with that golfer on another occasion. And that's an indicator of an independent contractor relationship, because there's an opportunity for profit and loss there. The caddy could make the money by taking them out, but it's really more hassle than it's worth. So they have the ability to reject that. But you also have to keep in mind too, that sometimes on occasion, subtle things happen, that if a caddy rejects certain jobs, if it's a larger course and there's a caddy master, the caddy master bumps that person down to the bottom of the list. So, I mean, those little things, the Department of Labor may look at that, because a caddy may say, this is supposed to be an independent contractor relationship. I rejected this job because I didn't like Rick. He's a terrible golfer and a bad guy. And because I wouldn't take that job, the caddy master put me at the bottom of the list. And so that sort of exhibits more of what I was talking about with respect to who controls the relationship. best practices. You know, it's not gonna automatically convert this into an employment relationship if there's a situation where payment is somehow funneled through the club, but direct payment would be better. So the instructor sets up a Venmo, the individual who's instructed pays him directly via Venmo or cash or however it's handled. The same thing with the caddy. Just a couple recent issues that I'll identify because there's lawsuits out there, and I currently am defending a number of wage and hour class action lawsuits. Nothing currently that I have related to caddies or instructors, but a lot of it happens in the trucking industry, and other general contractors have issues with misclassification issues. But here's just a few recent ones related to your industry. There's a caddy lawsuit in Florida in 2016 that was dismissed, and there's a couple others that were settled outside of court, and then there's a couple that are still ongoing. I'm not aware of any golf instructor lawsuits, class action lawsuits, or even individual lawsuits, but there was a tennis pro one in Georgia just 2 years ago that was settled. And I just wanted to mention one bill, and other states, perhaps legislation will start to rear its head in other states. There was a bill in New Jersey in 2021 that would have exempted caddies as independent contractors. So there really wouldn't have been an issue there. It would have been straight up, okay, you're a caddy, you're meeting all the requirements of the independent contractor relationship, so you are an independent contractor. But that ultimately sort of died on the vine. It was passed, and then it just sat in the governor's desk. He didn't sign it, so it was a pocket veto. So that's no longer out there. I'm not aware that it's been reintroduced. It's possible, but I haven't heard anything. The potential liability, there's costs involved here, and it's cost to both sides. So if you're a caddy or golf instructor and you have an issue here, you'll need to seek out an attorney, and I will advise you that these lawsuits don't get resolved overnight, and they're very expensive. They drag on for years and years. The only folks who make out in these lawsuits are generally the attorneys, which is good for me, bad for you. So, it's a long haul. It's a frustrating haul. There's soft costs involved. It's not just simply paying an attorney, but it's sitting for depositions, producing documents, and everything associated with that. For an operator, the potential damages are out there: back wages, overtime, payment of benefits, and then other issues related to your individual state's workers' compensation bureau and unemployment service center, as the case may be.
Hey, Rick, got a question for you on that one. What is the reach back period allowed for back pay?
That's a great question. So, and I'll give you the lawyer answer. It depends. So under the Fair Labor Standards Act, which is the federal law, it's a 2-year look back period, although it can be extended to 3 years if it's determined that and I'll use employer in quotes here, the employer or the organization acted willfully to violate rights. So in other words, they knew this was wrong and they did it anyway. They just didn't give a darn. So it can be extended back to 3 years. In Pennsylvania, it's 3 years period. So I see a lot of cases in PA where attorneys will file a case that sets forth both violations of the Federal Fair Labor Standards Act and the state's Pennsylvania's Minimum Wage Act. And so you do have a 3-year look back period. So it varies state by state. New Jersey, it's a 6-year look back. So it's across the board, but I would say generally, think about 3 years because that's probably the average nationwide. So that's the end of my presentation, droning on. And, if we have any questions, we're certainly open now. Taylor and Ronnie are prepared for questions, and we're happy to answer them.
Rick, I had another one I wanted to ask, going back to one of the points you made on the location. We have a lot of golf courses that are remotely located, and we may have an independent contractor who's a golf instructor, teacher, who really loves what they do and want to remain independent contractor, but there's only one facility, one green grass facility in their location. What is the best way for them to ensure that their business model can be sustained?
Well, the best way for them to ensure would be to meet the other factors. If geography limits their ability to jump around, then it has to be presented as that. It has to be presented that to the Department of Labor, and that's something that they're going to have to take a look at and say, listen, every single other factor here is met as far as the independent contractor relationship, or the majority of them. The only one that's missing is moving around course to course. And oh, by the way, there's a reason for that. They're limited by geography. They're not going to travel 200 miles to another green grass course to give instruction, because this is the one that's in their geographic proximity and within their wheelhouse. Again, and these are all fact-specific cases, and each element has to be fleshed out adequately to be able to maintain that relationship.
Another question I've had come up is we have a number of golf courses that uses technology where the customer can make their reservation online for a lesson instructors. How is that relationship best managed to ensure that the relationship between the independent contractor and the golf course does not cross over? In other words, to make it convenient for the customer, they use the technology of the golf course to make their make their reservation. So what is the best way to maintain that business model?
And there's nothing wrong with doing that at all. And that's something that I think needs to be expressed again in the agreement, said as part of, here's what services are going to be provided by the contractor. Here's what here's what the course is going to provide, in turn, and specifically include in there, instructor will have the ability to be assigned trainees, or caddies will be ability to assign golfers via or through the company's scheduling software. And, the parties understand and agree that, because the club is providing this is part of the compensation to be paid to the instructor. I mean, you want to tie it into somehow part of the agreement and part of the services and compensation.
Another one that I get a lot of times, golf clubs will want to have a youth camp in golf camp.
Yes.
And they use their independent contractors to come in and to do some teaching and training for their camps. Mm-hmm. In those cases, the club is setting the fee for the user.
Sure.
So in that case, the independent contractor defines what he's going to be charged the club to perform that service, or is that the correct way to go?
No, I think that's the correct way to go. I mean, the club certainly can establish that, okay, it's going to be $500 a kid to come to the golf camp, and then separately negotiate with the contractor what the contractor's fee for that is. And again, then that would revert back to all the elements of the independent contractor agreement as to, what's the contractor's background, are they professionally, these are type of services they provide professionally, do they have an independent business? No, I think that's perfectly acceptable. But again, fact specific, based on what you're telling me, that to me seems to be okay. But, there's all these other factors that may impinge on that.
Yeah, and I think you cover this when we talk about what type of training the golf course can deliver or can provide mandatory training for the independent contractor. Those would be those same rules and regulations like OSHA and other departmental requirements for anyone who comes onto their property. They must ensure whether you're delivering bread or soft drinks or whatever, you have to have certain basic training before you come on and do business on that golf course. So provide that without impeding on their independent contractor status.
Correct. As long as if that's something that they're providing to all vendors or all contractors. So in your example, delivering something to the premises, and they can show that, yeah, this is, the bread guy who delivers, he also has to be aware of these. And this isn't, as long as you're doing that consistently, applying it to all vendors, all contractors, then you're going to be okay for the most part. I want to make clear too, I don't want to suggest that. So most employers have, for example, a sexual harassment policy. You certainly can advise any independent contractor who provides services like a caddy or an instructor, you could advise them of the policies and procedures of the organization, that we don't permit harassment on any basis, and things along those lines, and have a sign off for that. So that's not necessarily training. That's more in line with what you're talking about, what your legal responsibilities are as someone who owns and operates a business.
Right. Okay. I saw the questions I had, and
Okay.
Hopefully the audience will have a question or two.
Yeah, we've had a couple come in. Thanks to Patricia for watching on Facebook. She asks if I can't recall when this was posted, but is anything you covered, Rick, differ for a city-owned municipal golf facility?
Yeah, that would be no, yes and no. And sorry, Patricia, that's a lawyer answer again. But it would depend on what local regulations that are set forth by the city. Now, that's not necessarily, what we're talking about here is the independent contractor relationship versus an employee relationship. That's not going to really change, based on location, whether it be a city-owned facility or not. But there may be stricter regulations in the city in the locality regarding how you define these type of things. So in a general sense, the answer is there's no difference. But in a more specific sense, it would require review of city regulations and policy as to how these things are established.
I see Chris asks here, if caddies are employed by an organization, can they be paid at a rate as a tipped employee, like a server?
Now, Chris, that's a great question. And the short answer is no. I mean, the carve out under the law is specifically for servers. And there's been a lot of discussion nationwide on, one of the benefits to an employer of doing it that way is this whole thing of a tip credit as it relates to whether you're paid the minimum wage. If we're talking caddies employed by an organization and not independent contractor relationship, then the compensation can be laid out in whatever manner they want. I mean, they can certainly offer as part of your compensation as a caddy would be, yeah, you're going to get a percentage of tips. Everyone's going to put it in the tip jar and we're going to split it up. But the caddy would still have to be paid minimum wage for all hours worked. It's a little different question than the independent contractor. If that's set up like that, then that's definitely not going to pass the independent contractor test.
All right, thanks. And one from Kellyanne. So I'm an independent contractor at a golf course. I have my LLC. Now the camps and clinics I run then go and use high schools and college kids as independent contractors. Is that still going to be allowed? And she also commented, or will the course have to pay those extra helpers? Or now do I have to hire them under my LLC as employees?
Yeah, Kelly, that's a very specific question that would relate, I think, to where you're located. I think speaking in generalities, you're good to go. You're an IC, you have your own LLC, you run the camps and clinics, and then use college and high school kids as independent contractors. I mean, I guess the question is, in that circumstance, it's sort of akin to a general contractor subbing out individuals. So again, I'm a general contractor on a residential site. as a general contractor, I have my own LLC and business, but I am not, I need someone to do the roof. I'm not a roofer. I need a subcontractor to do the roof. And so, under the circumstances, I would enter into an independent contractor. I would enter an agreement with a roofing subcontractor to perform the work. And that, that seems to be, I think that's what you're sort of getting at here. I hope that, yeah, I mean, you can, if you're paying, if you're, I'm looking at the follow-up question now. The question is, do I have to hire them? Employees? No, yeah, I mean, you don't have to hire them. The safest thing would be to hire them as your employees. But again, if you enter into an arm's length independent contractor agreement with them, that they are providing services on this, on these various camps, then under the circumstances, yes, you can enter into independent contractors agreements with them under your, with your LLC. And again, I would liken that to a general contractor hiring a plumber or a roofing contractor or whatever it would be.
There's another one came in from Ace Golf Riverview on Facebook, asks, how might a percentage of lessons paid back to the golf course or facility affect the independent contractor relationship, if at all?
I think it would affect it, and it would tend to show that this is more of an employment relationship, unless the big caveat being that's outlined specifically in a written agreement as part of compensation, as part of the contractor's ability to use the course or facility. So in other words, it's a facility fee. So if I come there, just same as renting a banquet room, I'm coming there, I'm renting this room, for a fee, and, but I'm going to have the ability to have my band play that night and use the facility and collect money based on the gate receipts. So I think it does affect it, but I think it needs to be clearly set forth in any agreement as to how that affects it. I mean, part of the compensation is agreed. It goes back to the facility or to the golf course, as, in essence, they're leasing the premises to you as an independent contractor to perform your services.
Awesome. Kelly says thank you. Kristen commented on Facebook: Can a person be both an employee and an independent contractor? When giving lessons, classifies an independent contractor, but when working for the business and doing their job, classify as an employee.
Thanks, Kristen. I mean, that's if you're talking about working at the course, but then separately giving instruction as an independent contractor, that does blur the line. And the Department of Labor will look at that and say, well, under the circumstances, they're already an employee. They're employed by you. This is just another service they're offering. Now, you can divorce the two a little bit by, again, having a separate independent contractor agreement, giving lessons maybe elsewhere as well, and setting up your own independent business. But that does blur the line a bit, because again, one of the things that the Department of Labor is going to look at, well, she's an employee, she's already doing this work for you. This is something that the course offers, and, under the circumstances, shouldn't be an independent contractor relationship.
Hey, Rick, question on that one, because we had another member who had that's a similar question. In their particular status, the employee after hours was given lessons with under no contract, no services, no support from the golf course. They were just only using their golf course or golf driving range to give lessons. Mm-hmm. And then they were working totally independent. They collect their own money. No money came to the club. Is that relationship?
Yeah. And if that's more akin to what Kristen was describing, then I'm more comfortable with that. I think that's certainly defensible. If it's entirely outside the scope of the club's hours, or whatever it may be, and it's a completely separate situation, then yes, that certainly makes me feel a little better that it would be defensible as an independent contractor relationship.
And as I told our member, that it's important to realize that it's the golf course, the club owner has the right to determine who can, come on, use their facility for personal gain.
And there's also liability concerns. So what if someone gets hurt? Who's it going to go back on? Is it going to go back on the owner? Probably.
Right.
There was a question earlier from Dan Costello. Speaking of the lawsuits, it was back when you were covering that. There are roughly 15 active lawsuits involving misclassification claims by caddies. He asked you to put on your, look at the crystal ball. Do you see the issue ever going away?
No, I mean, the issue's always been out there. So, some of these caddy lawsuits date back to early, like 2010, 2012, there's some 2015. So while, it does make a difference who's making the laws, and, in some circumstances, the law, there's mandates, like the Department of Labor, depending on the administration, gets a mandate from who's ever on high at the time, who's ever been elected, who's now in charge. We really want to pursue X issue because we think that's a big deal. And so right now, the Department of Labor's mandate is to pursue this independent contractor issue because they think it's a big deal. Now, should, in the subsequent years, we have different presidents, perhaps from different parties, that focus from the Department of Labor, for example, would lessen. So they may not be given that mandate. Okay, we're not that worried about the independent contractor relationship issue right now. What we're more worried about with respect to employers is OSHA violations. So that's going to be our focus now. So I don't think it'll ever go away, but it does ebb and flow depending on politics.
Rick, I think too, it's important to note that the majority, if not all of these lawsuits are occurring in states that are under the ABC rule, not the Department of Labor rule.
Okay. All right.
All right. I not seen maybe a few more seconds. If anybody has any final comments. And Ronnie, did you want we posted about the New York event coming up in May? Did you want to touch on that?
Yeah, for those that are in New York, we're going to be having a visit in New York. We're going to have a couple of luncheons. So we ask anyone who's interested in attending these. We're going to have some discussions on the independent contractor rule. We'll have some discussions on property tax issues. So again, we encourage you to join us. We got one event May 1st at don't have my notes in front.
It's at Sleepy Hollow.
Sleepy Hollow, right? I'm sorry, you took me down. Sleepy Hollow on the 1st, and then on May the 2nd, we'll be at the Heritage Club at Bethpage. So again, everyone's invited to this luncheon. You do need to register. So we encourage you to click on the link there to register if you're in New York or in nearby and you want to join us for those lunches. You don't have to be from New York. So again, hope you join us.
All right, one final question, and the thanks been coming in. Eric says thank you, and Patricia says thank you. Appreciate you all for watching and following. Chris asked, as our last question, since this rule is current, how long do organizations have to become compliant?
Well, it's 2:00 p.m. on the East Coast, so 2:10. No, in all seriousness, I mean, the rule has gone into effect. It's one of these sooner rather than later things. So there's no written grace period.
Yeah, Rick, I think one thing we need to share with the audience too is, because I get the question, does labor come out and do audits? And the direct answer to that is yes, they do. But generally what we found where they come up is when the state comes in to do a general audit and they see you have 1099s, and that's when they start engaging with labor.
And that's exactly right. Most audits, in my experience, I've been doing this 25 years, most audits are complaint driven. So someone has a complaint about something or other, related to unemployment, workers' compensation, or wages, the state begins an audit and they start going through things and decide there's a number of issues here need to be addressed. And all of that relates to 1099 because employers are audited for, making folks 1099 and avoiding workers' compensation payments and unemployment payments. And there is a sharing of information. When I first started doing this, 20 plus years ago, it was more siloed. So if you had someone from workers' comp come in, do an audit, everything's fine, or maybe there are a couple issues. There generally was less sharing of information between departments. But now, at least in Pennsylvania and some of the other states I practice in, Maryland and New Jersey to an extent, seems to be more of a sharing of information. So if you have someone from workers' comp come in, take a look, audit you, and see that there's problems with 1099s, it's likely that information may be shared with the unemployment compensation folks who, ultimately then may get kicked up to whatever state's Department of Labor may be for yet, another round of it. So yes, it is a lot of it is audit driven. A lot of it is complaint driven. A lot of the audits are complaint driven, although states have random audit processes in place as well. And you may just be the unlucky one of the draw.
One final quick one sneaking in here. Is it on the club or the member who's making the payment to issue the 1099 to the caddy?
Well, it depends on how, I guess, if I understand the question correctly, I guess it depends on how the compensation system is set up. So if it's a contracting relationship between the caddy and the club, and how is that compensation? Is the compensation paid to the club and then dispersed to the caddy? Does the member pay it to the club and then it's dispersed to the caddy?
I think that's what they're saying.
Yeah, then the club would be responsible for the 1099.
All right, excellent stuff, Rick. Thank you so much. Here, I'll put your information there on the screen, and folks appreciate you watching. And if you have any additional questions for us, don't hesitate to reach out to Ronnie Miles, our Senior Director of Advocacy. That's his email on the screen. You can always go to ngcoa.org/advocacy. That's our advocacy center. We have all the information there as well. We appreciate everyone for tuning in.
Thank you.
Yeah, Rick, thanks so much for your time. Ronnie, thank you, and have a great week, everybody.
Thank you.
Thanks.